What's up, TikTok? What's going on, TikTok? What's going on, TikTok? Good morning, everybody. Good morning. Good morning. Good morning. Good morning. Good morning. Bear with me. Tap the screen, share it live. Hey, TikTok. So, this is a petition. Motion for leave to proceed in form of offer. The affidavit of being broke. Go through some of these, alright? Declaration under penalty of perjury with the notary. Case number has not been assigned yet. Appendix A, B, and C is United States Court of Appeals, appears at Appendix A. The opinion of the United States District Court appears at B. For cases from state courts, Appendix C. The date on which the United States Court of Appeals decided my case was 3/11/2025. The date on which the highest state court decided my case was 11-7-2022. Almost 3 years ago. The jurisdiction of this court is invoked under 28 U.S. Code, Section 1257A, and Article 3, Section 2, Clause 2 of the United States Constitution. Table of contents, I got my questions presented on page 1, the jurisdictional statement on pages 2 and 8, treaty constitutional provisions involved 2 and 3, statement of issues presented 9, statement of the case 11, treaty violations and federal supremacy, page 11, waiver of sovereign immunity 11, judicial immunity limitations, page 11, relief requested, pages 11 and 12, conclusion, page 12, notice of void judgment and sworn affidavit 13 through 22, certificate of services is 23 to 26, attachments and appendices, pages 27 and on. Appendix A contains the 8th Circuit Court orders. Appendix B contains Iowa and South Dakota District Court orders. Appendix C, State Supreme Court order violating speedy trial rights, 1868 Fort Laramie Treaty. Appendix D has supporting affidavits and supplemental declarations. Appendix E contains exhibits of fabricated warrants, documentation, etc. Table of authorities, the 1868 Fort Laramie Treaty, 18 U.S. Code, Titles 241. Maybe I could just show you guys. But this is the table of authorities here. So the petition for the Supreme Court, these are my questions presented. And we'll go through this here today as much as possible, and I'll show my original state habeas corpus, the docket to that, and what I filed in that.
Thank you for the
Questions
taps.
presented are whether a state court judgment obtained through fabricated arrest warrants, lack of proper jurisdiction, and prosecutorial misconduct is void ab initio and violates the due process clause of the 14th Amendment. Question number 2 is whether the Fort Laramie Treaty of 1868 is a supreme law of the land under Article 6 of the U.S. Constitution, preempts state jurisdiction over treaty beneficiaries, and renders all state criminal proceedings against such individuals void. 3, whether systemic violations of the Sixth Amendment, namely ineffective assistance of counsel, denial of a speedy trial, and coercive plea bargaining tactics and practices warrant vacatur of the conviction and reversal of lower court rulings. 4, whether judicial and prosecutorial immunity can shield officials who engage in actions outside the scope of lawful jurisdiction and commit fraud upon the court. 5, whether the state of South Dakota has waived sovereign immunity by codifying consent to suit and engaging in ultra vires acts, violating both federal law and treaty obligations. Party to the proceeding, myself, Petitioner Daniel Gomez, a lineal descendant of the Sioux Nation of Indians, Santee Sioux Tribe, and the treaty protected individual under the 1868 Fort Laramie Treaty. And we the people. Respondents, Elk Point, Union County. Chief Justice of the South Dakota Supreme Court, Stephen R. Jensen, the state of South Dakota. Deputy Mike Palmer of the Union County Sheriff's Office. Melissa Larson, a clerk of court of the Union County Courthouse. Jerry Miller, prior prosecuting attorney of the state of South Dakota for Union County, Elk Point. Michael J. McGill, a surrogate prosecutor appointed to represent and assist me in this case, who in turn assisted the state's prosecutor in obtaining a false confession and conviction. Roberto A. Lange, a United States District Court judge, federal judge. Nicholas A. Davis, a police officer with the North Sioux City Police Department. Chad Stroman with the Sioux City Police Department of Iowa. The city of Sioux City, the state of Iowa, the city of Sioux Falls, and probably some other ones I didn't list in there. As long as my point gets across. The opinions of the United States Court of Appeals for the 8th Circuit, numbers 25-1114, number 25-1115, number 25-1512 has not yet been published or is attached in the appendix. The decision of the U.S. District Court for the District of South Dakota, case number 424 CB 04216, denying relief is also included in the appendix. Jurisdiction. This court has jurisdiction under 28 United States Code 1254, Section 1. The final judgment of the 8th Circuit was entered on 3-11-2025. Article 3, Section 2, Clause 2. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Constitutional and treaty provisions involved. United States Constitution, Article 6, Clause 2, the Supremacy Clause. Article 3, Section 2, Clause 2 is the jurisdiction. U.S. Constitution, 1st, 2nd, 4th, 5th, 6th, 7th, 8th, and 14th Amendments. The Treaty of Fort Laramie, 1868, Articles 1 through 16. The Speedy Trial Act, 18 United States Code, Section 3161, et sequestrum. Title 18 U.S. Code, Sections 241 and 242, Conspiracy and Deprivation of Rights. 42 United States Code, 1983. Civil rights violations. Statement of the case. Petitioner seeks redress for a series of egregious constitutional violations, treaty breaches, and jurisdictional defects that render all state criminal proceedings against him void ab initio. The petitioner is a direct descendant of an enrolled Santee Sioux tribal member protected under the Fort Laramie Treaty of 1868, a binding instrument that preempts state authority over treaty beneficiaries. Despite this, the state of South Dakota fabricated arrest warrants without a valid charging instrument or lawful jurisdiction, subjecting petitioner to an unlawful detention, kidnapping conspiracy under color of law, coercive plea negotiations under threats and duress, and a fundamentally defective judicial process. Throughout the proceedings, petitioner was deprived and denied the effective assistance of counsel, speedy trials, the ability to confront and cross-examine witnesses, and other constitutional rights. Was not timely brought to trial under the Speedy Trial Act or the Sixth Amendment, and faced judicial and prosecutorial misconduct. Conduct that falls outside any legal immunity or jurisdiction was never lawfully established. The courts below dismissed these substantial claims, erroneously deferring to doctrines of immunity and finality, while ignoring constitutional and treaty violations that strike at the heart of fundamental justice and the supremacy of federal law. Reasons for granting the writ. This case presents urgent constitutional questions of national importance. Thanks for the likes. This court has long held that due process cannot be satisfied where criminal convictions rest upon fraudulent, jurisdictionless proceedings. A system that allows states to override the U.S. Constitution and federal treaty obligations threatens the foundational structure of law. 2. Treaty rights and federal preemption demands clarification. The Fort Laramie Treaty remains legally binding. Its preemptive force has been ignored by state courts, infringing on tribal sovereignty and federal supremacy. This court must resolve the scope of state power in light of treaty obligations. 3. Void judgments cannot be shielded by immunity. This court must determine whether doctrines of judicial and prosecutorial immunity can apply to ultra vires actions arising from fabricated process, fraud, and acts taken absent jurisdiction. 4. The erosion of speedy trial rights and due process is a national crisis. The lower courts failed to remedy violations of petitioners' speedy trial rights, coercive plea bargaining, Miranda violations, and ineffective assistance of counsel, undermining the Sixth Amendment's core guarantees. 5. State waiver of sovereign immunity to codification must be addressed. South Dakota law expressly permits suit against state officials acting beyond their authority. The court must clarify the boundaries of state immunity where the state, by statute and action, has consented to liability. This petition presents weighty constitutional and treaty-based questions with national implications. The integrity of federal supremacy, tribal sovereignty, and due process demand review. Petitioner respectfully requests that this court grant the writ of certiorari and vacate the unlawful state proceedings. I, Daniel Gomez, a living man and natural person, hereby declare and assert my status and inherent rights as a legal descendant and affiliated citizen of the Osheti-Shakwa Great Sioux Nation, specifically of the Santee Sioux tribe. My standing is not merely statutory, but rooted in ancestral birthrights, indigenous sovereignty, and the supreme law of the land under Article 6 of the United States Constitution. 2. This declaration invokes the supreme authority of the 1868 Fort Laramie Treaty and a binding nation-to-nation agreement between the United States and the Sioux Nation. Said treaty, ratified by the United States Senate and codified under federal law, remains in full legal force and supersedes all conflicting state statutes, codes, or procedures under the Supremacy Clause. This is a copy of that Fort Laramie Treaty. From this day forward, peace between the parties to this treaty shall forever continue. Shall forever continue. The government of the United States desires peace, and its honor is hereby pledged to keep it. If bad men among the Whiteys or other people subject to the authority of the United States shall commit any wrong upon the person or property of the Indians, the United States will proceed at once to cause the offender to be arrested and punished according to the laws of the United States, and also reimburse the injured person for the loss sustained. See that part? As a protected treaty beneficiary and a constitutional beneficiary, I am entitled to the full spectrum of inherent and unalienable rights preserved under the treaty, including but not limited to due process of law, liberty from unlawful seizure, recognition of tribal jurisdiction, and protection from sovereign governmental encroachments, including those perpetrated by state actors who have no lawful authority over treaty-protected persons or lands. The state of South Dakota, as a political subdivision of the United States, has no lawful jurisdiction to impose its codes, criminal procedures, or prosecutorial authority upon me in violation of the 1868 Fort Laramie Treaty. The United States Supreme Court has long held that treaties with native nations are the supreme law of the land, and that state interference with such treaties constitutes an ultra vires act, void ab initio. I further declare that my involuntary subjection to state criminal proceedings initiated through fabricated arrest warrants and prosecutorial misconduct, police brutality, assaults, and attempted assassinations constitutes a direct violation of my treaty-protected liberties and a breach of fiduciary duty owed by both state and federal actors under trust obligations established by federal Indian law, constitutional law, and international norms. The repeated acts of legal fraud, deprivation of rights under color of law, and systemic failure to honor the Fort Laramie Treaty render any and all legal processes executed by the state of South Dakota against me null, void, and without jurisdiction. I stand upon the law, natural, constitutional, and treaty, and invoke the lawful protections afforded to me under the Fort Laramie Treaty, the Constitution of the United States, and the sacred doctrines of indigenous sovereignty recognized in domestic and international law. This court has jurisdiction under 28 U.S. Code 1254 and Article 3, Section 2, Clause 2, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party. The Supreme Court shall have original jurisdiction. This court has jurisdiction under 28 U.S. Code Sections 1291 from a final order of the U.S. District Court for the District of South Dakota, case number 424 CE 04216. The lower courts dismissed petitioner's constitutional and treaty-based claims without proper adjudication on the merits. This appeal involves federal questions under 28 U.S. Code Section 1331 and Sections 1343, and constitutional deprivations actionable under 42 U.S. Code 1983, 1985, and 1986. Whether fabricated arrest warrants and criminal charges lacking lawful jurisdiction render the state judgment void ab initio. Whether petitioner's constitutional rights under the 1st, 2nd, 4th, 5th, 6th, 7th, 8th, and 14th Amendments were violated through unlawful arrest, prosecutorial misconduct, denial of counsel, and coercive plea bargaining. The underlying judgment is void ab initio due to fabricated criminal process, lack of jurisdiction, treaty violations, and systemic due process breaches. Judicial and prosecutorial immunity do not protect ultra-vires acts committed outside lawful jurisdiction. South Dakota cannot invoke sovereign immunity where it has statutorily waived such protection. Further, the state's prosecution of a treaty-protected individual under the invalid process violates both the U.S. Constitution and the Supremacy Clause. The District Court erred in dismissing the matter on procedural grounds while ignoring substantial constitutional and legal defects in the underlying cases. Argument: void judgment and fabricated warrants. The judgment rendered against appellant is void, not voidable, due to the absence of a valid arrest warrant, indictment, or lawful jurisdiction. Fraud upon the court, including fabricated process, renders any resulting order a legal nullity. Sea Valley versus Northern Fire and Marine Insurance Company, 254 U.S. 348, 1920. United States versus Throckmorton, 98 U.S. 61. Judicial and prosecutorial misconduct. Appellant documented judicial and prosecutorial misconduct, including knowingly relying on void warrants, failure to verify jurisdiction, obstruction of exculpatory evidence, coercion of plea negotiations without probable cause. Such actions constitute fraud and constitutional violations beyond the scope of judicial immunity. See Forrester versus White, 484 United States 219. Stump versus Sparkman, 435 United States 349. Ineffective assistance of counsel. Appellant was deprived of effective representation as guaranteed by the Sixth Amendment as counsel failed to challenge jurisdiction, object to fabricated process, protect treaty rights, and demand a speedy trial. See Strickland versus Washington. Speedy Trial Act and Sixth Amendment violations. Petitioner's right to a speedy trial under 18 United States Code Section 3161 and the Sixth Amendment was violated by extensive delays and non-compliance with statutory deadlines. The failure to enforce speedy trial rights renders the conviction constitutionally infirm. See Barker versus Wingo. Coercive plea bargaining and Miranda violations. Appellant was coerced into plea bargaining under threat of enhanced charges and without full Miranda advisement, violating Fifth Amendment protections and established due process standards. See Brady versus United States. Treaty violations and federal supremacy. The 1868 Fort Laramie Treaty is supreme law under Article 6, preempting conflicting state actions. Petitioner is protected as a tribal descendant under this treaty, and any state court action against him absent federal authorization is null. See Worcester versus Georgia. Montoya versus United States. Waiver of sovereign immunity. South Dakota codified waiver of sovereign immunity through statutes authorizing civil rights claims against state officials who act outside lawful authority. See Ex parte Young, 209 United States 123. South Dakota codified law sections 21-32-16, 21-32A-1. Judicial immunity limitations. Immunity does not extend to acts taken in the absence of jurisdiction or with malicious intent. Fraudulent conduct, conspiracy to violate rights, and abuse of office are not judicial acts protected by law. See Pulliam versus Allen. Dennis versus Sparks. Relief requested. Appellant respectfully request the following: reversal of the district court's dismissals, vacatur of the state court judgments as void ab initio, remand for full hearing on constitutional and treaty-based claims, declaring Declaratory judgment recognizing the supremacy of the 1868 Fort Laramie Treaty. Injunctive relief against further state action violating treaty and constitutional rights. 6. Compensatory and punitive damages under 42 U.S.C. 1983, 1985, and 1986. This case implicates fundamental principles of due process, tribal sovereignty, and federal supremacy. The lower court's refusal to address the jurisdictional and treaty violations constitutes a miscarriage of justice. Appellant respectfully requests this Honorable Supreme Court reverse the District Court's decision and remand for appropriate relief. Notice of void judgment. Notice of void judgment and sworn affidavit due to lack of jurisdiction, judicial misconduct, prosecutorial misconduct, and violation of oath of office, violation of rights. 2 Elk Point Union County Court regarding case numbers: State of South Dakota versus Gomez 63C 0800023780, South Dakota habeas civil 09-389, South Dakota versus Gomez 63C 0800028680, South Dakota Supreme Court case counter complaints number 30364 and number 30100, filed in the South Dakota State Supreme Court. Notice to court and all parties involved. This notice is hereby issued to declare the judgment process rendered in the above referenced cases as void ab initio on the grounds of fraud, lack of jurisdiction, judicial misconduct, prosecutorial misconduct, and violation of oath of office by the presiding judicial officers of the courts. Lack of jurisdiction. The court is hereby notified that it acted or is acting outside its lawful authority by issuing a summons or judgment without proper jurisdiction over the matter and all parties involved. Jurisdiction is fundamental and must be established on the record at every stage of proceedings. Any judgment rendered without jurisdiction is null and void and lacks any legal effect. The following points summarize the lack of jurisdiction in this case. Melissa Larson, on June 7, 2008, conspired with Deputy Palmer to impersonate a magistrate judge and issue a predated fabricated warrant of arrest after Deputy Palmer and Nicholas Davis made the arrest of June 7, 2008. Said warrant was predated to February 2, 2006. Affidavit of myself under the penalty of perjury. I attest, swear, and affirm that the statements herein are true and declare and give notice comes now. I, petitioner, will testify substantially as follows and move the court to take judicial notice of the deprivation of rights under color of law conspiracy by North Sioux City Police Officer Nicholas Davis, Union County Clerk of Court Melissa Larson, Union County Sheriff Deputy Palmer, Supreme Court Judge Stephen R. Jensen, South Dakota State Senator Art Roosh, court-appointed surrogate prosecutors Michael J. McGill, Philip Peterson, John Slattery, and South Dakota State's Attorney Jerry Miller. All evidence of this conspiracy against rights and kidnapping at the Pronto Stop in North Sioux City, South Dakota on June 7, 2008. As such, kidnapping was committed in violation of Title 18 U.S. Code 241 and Title 18 U.S. Code 242, and of the 4th and 14th Amendments to the United States Constitution and the counterpart contained in the South Dakota State Constitution relating to unreasonable searches and seizures of persons and property, as well as SDCL 23A-2-2, which deals with the issuance and execution of warrants. Specifically, this notice refers to falsified police report by Nicholas Davis and fabricated forged warrant of arrest by Melissa Larson and Deputy Palmer. In the narrative case report prepared by Officer Nicholas A. Davis of the North Sioux City Police Department and consisting, among other things, of the call from Deputy Palmer to Melissa Larson regarding this conspiracy of kidnapping under color of law, which acts and omissions occurred and were conducted by Officer Davis on June 7, 2008, approximately 1:40 a.m. to 2 a.m. Under 18 United States Code 1201, a person is guilty of kidnapping who unlawfully seizes, confines, inveiges, decoys, kidnaps, abducts, or carries away and holds for ransom or reward or otherwise any person. The warrant was false and fabricated. Deputy Palmer, Nicholas Davis, Melissa Larson, Jerry Miller, Stephen Jensen, and the South Dakota State Bar conspired to deprive me of my rights, my life, and my liberty, subjecting me to a malicious prosecution and false imprisonment, holding me for several years in the South Dakota Department of Corrections under inmate ID 50853 and subsequently 52426. This conspiracy involves Sioux City Police Department officers and Woodbury County Jail officers. I posted a TikTok link on here for the recorded call to Manny Scarman, a parole agent with the Iowa Department of Corrections, asking about the existence of any warrants, and Manny Scarman's response call. I was on parole in Iowa of December of 2006. And I flat turned in 2008, February of 2008. But I was continuously under their supervision or in their custody from October 12th of 2005 all the way until December of 2006. So there's no way I did anything on February 2nd of 2006. I was in custody. And furthermore, since the Department of Corrections of Iowa released me on parole during this alleged warrant that they had, the state of Iowa would never have released me on parole had it been an active warrant. So that right there is proof and evidence that there was no warrant in existence. So they fabricated that warrant. And when they did my background check, they noticed that I was in prison from March of 2006 until December. So they tried to predate that warrant to a time before I was in prison. But that record search doesn't count the time because you get that on a sentencing order that you was in jail prior to sending to prison. So you're in jail before you go to prison. But that public records check doesn't turn out unless you get the transcripts from the court where the court gives you credit for time.
No case number. Case number? No case number.
Anyways, I put the other link in there for the response call from Manny Scarman, Department of Corrections, parole officer. The execution of the false and fabricated warrant was faulty because the forged warrant of arrest, contrary to the provisions in SDCL 23A-2-2, the fabrication of the day only warrant to an anytime warrant happened orally and by the Union County Clerk of Court, Melissa Larson, who predated the warrant for February 2nd, 2006, on or about or after June 7th, 2008, rather than written by a magistrate judge as the South Dakota Codified Law provision requires. The statute reads as follows. It's Rule 4A. Warrant or summons issued on complaint, sworn oral testimony. Failure of defendant to respond to a summons, if it appears from a complaint or from an affidavit or affidavits filed with the complaint, that there is probable cause to believe that an offense has been committed and that a particular person has committed it, a warrant for the arrest of that person, if requested by the prosecuting attorney, shall be issued to any officer authorized by law to execute. If circumstances make it reasonable to do so in the absence of a written affidavit, an arrest warrant may be issued upon a sworn oral testimony of a person who is not in the physical presence of a committing magistrate. If the committing magistrate is satisfied that probable cause exists for the issuance of the warrant, the sworn oral testimony may be communicated to the magistrate by telephone or other appropriate means and shall be recorded and transcribed. After transcription, the statement shall be certified by the magistrate and filed with the court. The statement shall be deemed to be an affidavit and complaint for purposes of this section. Upon the request of the prosecuting attorney, a summons instead of a warrant shall be used. More than one warrant or summons may be issued on the same complaint. If a defendant fails to appear in response to a summons, a warrant shall be issued. So I sent a copy of this to all the respondents, right? So I'm declaring the penalty of perjury and sworn oral testimony, and I'm doing it again here on TikTok. So I'm also requesting warrants to be issued for them to come and be confronted with these accusations. And they can call each other as witnesses for the defense or whatever. They can try to cross-examine me. I don't know. What do you think they would do? Emphasis added. A warrant did not exist in this case, but for Melissa Larson's fabricated one, tampering with records, creating one maliciously, which was a date-only arrest warrant for failure. So they told me it was a failure to appear. The lawyer told me that, and then I'm discovering that, well, I don't even have a warrant in this record for failing to appear. It's just a warrant with a charge on it. So that I couldn't fail to appear if they never issued a summons. So that's a denial of due process. If there wasn't a warrant in existence, then Iowa was guilty of denying me due process by failing to tell me that a warrant existed and allowing me the opportunity, like every other prisoner in Iowa got, to call this Union County and take care of it. So I was never notified of it. But again, I got the recorded call to Manny Scarman, and he did his little record search, and there was no information on the warrant. So I would most definitely charge Manny Scarman as well if he was in on it. Anyways, a day-only arrest warrant for failure to appear, a misdemeanor. See? a misdemeanor. So when I get the next failure to appear, when I actually did fail to appear because I was in county jail again, and this time I knew I had the warrant, and I'm telling them, hey, I got court, and they didn't want to transfer me because South Dakota didn't issue a warrant. So they caused me to miss my court date, and then I was subsequently charged not with the misdemeanor failure to appear, but with the felony second-degree escape charge. And mind you, I had bonded out on that, right? And all this stuff is in here, all the evidence is in here. I got the bond paper I signed, I got the court order, and the notification they gave me that I would be charged with the failure to appear, and then when they go through and charge me with escape, that becomes a malicious prosecution. Now, in order for them to achieve me to give a false confession, they used my attorney that was supposed to assist me in my defense. And he turned around and all he did was assist the prosecution obtain a false conviction, a wrongful conviction. And I paid that lawyer. I paid him all the fines and restitutions for that. The amount exceeds $20, so my Seventh Amendment right to a civil jury trial is preserved. They can't waive that. That's an inalienable right. Because a failure to appear charge is a misdemeanor, then by statute the warrant is day only and may only be converted into an anytime warrant by the signature of a judge. Black's Law Dictionary revised 4th edition defines endorse through reference to endorse as to write a name on the back of a paper or document. The context here is in negotiable instruments law, but given that the statute clearly says upon the warrant, the principle is the same. Endorsement as an authoritative signature upon a physical instrument. Even if the clerk, acting as a magistrate, no, she wasn't acting, she was impersonating. Impersonating a magistrate somehow had the authority to issue or modify the warrant. Such modification in this case would not have been statutorily valid because it was not written on the document. Furthermore, Gomez was in the custody of Woodbury County Jail from October 12, 2005 through March 6, 2006, conducting a jury trial before the Honorable Dwayne E. Hoffmeyer of the Sioux City Courthouse. Present prosecuting attorney was Bridget Barnes, and defense counsel was Peter Van Etten. I was held in the custody of the Woodbury County Jail of Sioux City, Iowa, and on March 6, 2006 through December of 2006, I was held in Iowa Department of Corrections in Clarinda, Iowa, continuously. Given the invalidity and criminality of the false and fabricated warrant and execution of the seizure, my arrest was not valid. Therefore, a deprivation of rights under colored law, kidnapping in violation of Title 18 U.S. Code 241 and 242, a conspiracy by and through the Elkhorn Union County employees, and North Sioux City Police, and subsequently Sioux City, Iowa Police Department, and Chad Stroman of the Sioux City Police Department and Woodbury County on July 7, 2008. Any unlawful seizures conducted pursuant thereto are similarly invalid, and the results of such, as well as any statements or false confessions made by myself to police or the courts while in custody from these unlawful seizures and kidnappings are inadmissible as fruit of the poisonous tree. Wong Soon versus United States. For the reasons stated above, I move that this court enter an order vacating and exonerating Gomez of all crimes, and to order summons and warrants of arrest be issued for Watterson, Davis, Jensen, McGill, Miller, Slattery, Peterson, and Palmer for the crimes of conspiracy to commit kidnapping under colored law, for the false arrests and false imprisonments and malicious prosecutions of June 7, 2008 by David Davis et al. And July 7, 2008 by Chad Stroman et al. And find that the defendants deprived Gomez of rights under color of law. Additional testimony regarding the kidnapping under color of law of my person, the false arrest and conspiracy to deprive rights under color of law by Nicholas Davis et al. At the Pronto Stop in North Sioux City, South Dakota on June 7, 2008, and subsequent false arrest and kidnapping by Chad Stroman at 910 16th Street, as such acts were committed in Dakota Treaty territory in violation of federal and state laws. Treaties, the 4th, 5th, 6th, 8th, and 14th Amendments to the United States Constitution, and the counterparts contained in the South Dakota and Iowa state constitutions and state laws, which relate to kidnappings and warrantless seizures and searches and seizures of persons. Specifically, this motion refers to acts and omissions specified and falsified in the narrative case report prepared by Nicholas Davis of the North Sioux City Police Department. These kidnappings were conducted by Nicholas Davis on June 7, 2008, and subsequently Chad Stroman of the Sioux City Police Department on July 7, 2008. The recent, well, it's not so recent anymore, but the South Dakota Supreme Court decision in State versus Hagan, 2008, SD 41, supports this information. In Hayen, a police officer stopped Wade Dustin Hayen because Officer Flogstead could not see the expiration date on the temporary license plate because it was blocked by objects in Hayen's pickup bed. Officer then walked by the temporary plate, able to see the date but not bothering to look at it. The officer, after dispelling his suspicion for the stop, proceeded to detain and investigate the subject. The officer was alerted to a warrant for Hayen's arrest and followed through with such, taking that opportunity to then search Hayen and his vehicle incident to the arrest. Finding illicit substances and paraphernalia, the circuit court granted a motion to suppress on the grounds that Flogstead's suspicion of criminal activity should have been allayed when he walked by the temporary plate and had the unimpeded ability to see the date. The officer had no further reasonable articulable suspicion that the person is involved in criminal activity unrelated to the traffic violation. Quoting State versus Ballard. Officer, by his own admission, only stopped the vehicle to check the expiration date of the temporary plates, and neither did he look at the license plate, nor did he offer any other reason to extend his investigation beyond verifying the date on the temporary license. The court goes on to cite the United States versus McSwain, the facts of which parallel those of my case, or the case of Hayen. McSwain had been pulled over because of an obscured expiration sticker on a temporary license. The officer saw as he approached the vehicle that the license was valid, but proceeded to question McSwain and seek to run his license. McSwain did not have a driver's license, but upon running his name through a check, the officer found out about numerous convictions and then sought permission to search the vehicle, which McSwain gave. The officer found a pew-pew, illicit substances, and a set of scales. Ultimately, McSwain prevailed in suppressing the evidence against him as fruit of an unlawful detention. For lack of any reasonable suspicion on the part of the officer that any criminal activity was happening or had happened. McSwain, at 560-62. The South Dakota court then drew the same conclusion in Hayen, noting that here, like in McSwain, the officer's actions in requesting Hayen's license and proof of insurance went beyond the limits of a lawful investigative stop. The officer could easily have looked at the license to satisfy his suspicions. Had he done so, it would have been clear that no violation had occurred or was occurring. At that point, his reason for detaining Hayen would have dissipated. He expressed no safety concern, he did not allege any observed violation of law, nor did he proffer any purpose for the continued stop. Without any further articulable suspicion of criminal activity, the extended detention violated Hayen's federal and state constitutional rights. Although there certainly are situations where an officer is permitted to make contact with the driver prior to investigating the purpose of the investigatory stop, in this situation there were none articulated. Therefore, the officer's request for Hayen's driver's license and proof of insurance constituted an unconstitutional detention, and the evidence garnered from the unlawful detention was properly suppressed. Like in McSwain and Hayen, Nicholas Davis had no reasonable, articulable suspicion to detain and investigate Daniel Gomez. His friend Angel, who did not have a driver's license, called Daniel to come pick him up at the Pronto gas station. Gomez showed up, and the police only learned that someone was coming to get Angel as Mr. Gomez was pulling up. The police did not know who was coming, nor was Angel involved in any criminal activity. The car I was driving was fully functional and proper to all appearances, with current registration, all lights working, etc. That's including insurance, I had a license, blinkers all worked, everything. The fact that's not in here is they didn't even pull over Angel. They pulled up to Angel as he was parked at a gas station waiting for me to show up. So David not only had no reasonable articulable suspicion to stop me or pull me over, but he didn't even make a valid stop with Angel. And to further that investigation into another car that showed up on scene, that's not reasonable, that's unreasonable, through and through. Officer Davis had no reasonable articulable suspicion to investigate the vehicles or drivers. Because the investigations were not valid, neither was the subsequent arrest pursuant thereto. Therefore, any searches conducted as a result of a kidnapping and unlawful false arrest are similarly invalid, and any evidence gained from such, as well as any statements made by myself to police while in custody from this improper arrest, are inadmissible as fruit of the poisonous tree, as termed by Wong Soon versus United States. For the reasons set forth herein, I therefore move that the court suppress and vacate any convictions and all evidence and statements resulting from his June 7, 2008 arrest and false confession to the crime of escape, whether in or out of custody. 2. Judicial misconduct. The conduct of the presiding judicial officers in this case is hereby called into question for actions and decisions that exceed lawful judicial discretion and reflect misconduct, warranting voidance of the judgments. Judicial misconduct includes, but is not limited to, the following actions. Stephen Jensen was aware of the fabricated warrants and the malicious prosecution of second-degree estate, having himself entered the order stating methods and conditions of bond that did not include an order to return to custody. Thus, he willfully and knowingly engaged in the conspiracy to commit a deprivation of rights under color of law kidnapping. Judicial officers are held to the highest standard of integrity, and misconduct undermines the legitimacy of any judgment rendered under such circumstances. The violation of oath of office. The presiding judicial officers, Jensen and Roosh, took oaths to uphold the Constitution and to administer justice impartially. Actions or rulings that contravene this oath render any decision made under such circumstances void, as they violate fundamental principles of fairness, impartiality, and the due process rights of all parties. Stephen Jensen, being a party to these proceedings, failed to recuse himself from counter complaints number 30364 and number 30100 in the South Dakota State Supreme Court, which decisions or rulings were biased and prejudicial. Declaration that judgments are void on issue. As a result of the aforementioned issues, these judgments are void and unenforceable. A void judgment is a nullity and is treated as if it never existed. Courts and officials must recognize that any actions taken based on this judgment are without legal effect. Under established case law and statutory provisions, a void judgment may be challenged at any time and in any court where it may be relied upon. This notice serves as an official declaration of the void status of the judgment and must be acknowledged as such by all entities attempting to enforce or act upon it. Request for immediate action. The court is hereby requested to vacate and dismiss any orders, warrants, or actions arising from the void judgments, cease all enforcement actions related to the judgment, acknowledge receipt of this notice, and provide confirmation of actions taken to remedy this matter within 15 days. Cobra versus North Carolina 386, United States 213. Upon the petitioner or the defendant's demand, the state has a constitutional duty to make a diligently good faith effort to bring him before the circuit court for trial. Smith versus Hood. South Dakota Speedy Trial Act, Raines versus Hollingsworth, to which are asked this court to issue an order disqualifying all judges of the Second Judicial Circuit Court pursuant to South Dakota Codified Law 15-12-21.1, SDCL 15-12-34, and South Dakota Codified Law 15-12-37. I bring this brief in support pursuant to SDCL 15-12-27. For purposes of First Amendment, law gives judges, lawyers, and other courts or state officials as persons or courts as institutions no greater immunity from criticism than other persons or institutions. Interest in protecting reputation from injury is insufficient reason for repressing speech that would otherwise be free. And interest in protecting institutional reputation of courts is entitled to no greater weight in the constitutional scale. Landmark Communications Incorporated versus Virginia, 1978. Gomez and 420 CV 04151 and Blackburn, case number 421 CV 04176, have provided sufficient evidence for Monell claim municipal liability. United States District Court, Second Circuit. Marchand versus Simonson. 14th Amendment, substantive due process, state law harassment. 3 possible grounds for Monell claims against municipal defendants. 1, the municipality adopted an unconstitutional policy. It shows you that, right? The municipality adopted an unconstitutional policy, right here. Signed by a judge, court seal, and the Supreme Court of the state of South Dakota orders suspending the law. They adopted this right here is the policy. The municipality adopted an unconstitutional policy. South Dakota Supreme Court judge ordered waiving speedy trial rights due to COVID pandemic, right here. It's in my hand. I provided this. That's one ground right here. This alone right here is one ground for that. The municipality failed to adequately train its licensed attorneys on constitutional rights of defendants. 3, the municipality failed to adequately supervise or discipline its judicial employees and court officers, agents, lawyers, and judges. The municipality, this whole state of South Dakota, who exercises supervision over the state courts? The federal courts. The Supreme Courts. This court is obligated to draw the most favorable inferences that pro se litigant plaintiff's complaint supports. Now that's another case. Somebody else shared a video yesterday with that, but there's Chavez versus Chapin. Down here. Chavez versus Chapin. This court is obligated to draw the most favorable inferences. So that's that liberal construction. Pro se pleadings are held to a less stringent standard. For respondent superior, you can cite these cases here. You can look up these ones. United States versus Stringer. See United States Department of Justice Criminal Resources Manual 162 3A46. Federal prosecution of business organizations. Again, the Solicitor General got all this. Rule 1.4, right? Dilatory practices. The appendix to South Dakota Rules of Court Communication. See attached rules and laws. Protections, privileges, and immunities secured by the Constitution by state and municipal actors, to include but not limited to judges, lawyers, jailers, wardens, parole officers, etc. Title 18 U.S. Code 241 through 242, under color of law. Article 4, Section 1 of the U.S. Constitution. The full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved. Comes down, state of South Dakota attempts to reclassify criminal history of one state located within Dakota Territory as a felony, and another state also located within Dakota Territory. A judicially established treaty territory ratified by Congress and contained in the Fort Laramie Treaty, where the act was not done within the state's jurisdiction to grant South Dakota jurisdiction to reclassify an offense in another state's jurisdiction, does violate Article 4, Section 1 of the U.S. Constitution,
Misdemeanor.
denying the full faith and credit to the records of Iowa within South Dakota state courts.
Misdemeanor.
So what they were doing,
Misdemeanor.
they were reclassifying misdemeanors into the state of Iowa and saying, well, if you had committed them in the state of South Dakota, those are considered felonies. So for habitual criminal felony purposes, you're looking at life. Coercive plea bargaining tactics.
Case number.
Even if it was a misdemeanor over there, it's a felony over here. If you had done that over here, so it counts as a 3 strikes.
Case number.
Conviction. How are you looking at life?
Double jeopardy, double jeopardy, double jeopardy. How many times are they going to charge me with the same thing?
State of South Dakota does not give full faith and credit contained within its own state's records, public acts, and least of all its judicial proceedings. A living witness is before you reading this supplemental testimonial. I was maliciously prosecuted by State's Attorney Jerry Miller of Union County, Elk Point, South Dakota, of second-degree escape. I declare actual innocence of escape. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary are notwithstanding. Constitutional Amendment 1. Congress shall make no law abridging the freedom of speech or the right of the people to peacefully assemble and to petition for a redress of grievances. South Dakota state legislatures lobbied for and enacted South Dakota Codified Law, Chapter 22-7-8.1, the habitual criminal statutes and others contained under that title and chapter, with deliberate indifference to the protections and immunities secured by the U.S. Constitution in violation of Title 18 U.S. Code 241, violation of Title 18 U.S. Code 241, conspiracy against rights, and Title 18 U.S. Code 242, deprivation of rights under colored law. Constitutional Amendment 5, which states in pertinent part, nor shall any person be subject for the same offense to be twice put in jeopardy, nor shall be compelled under threat, duress, or coercion to, in any criminal case, to be a witness against his or herself. A coerced guilty plea, a false confession, is you being a witness against yourself. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken. Minnehaha County State's Attorney's Office and the state, by and through its several employees, are deliberately indifferent to and knowingly and willfully engaged in the deprivation of rights under colored law, a direct assault on the U.S. Constitution. Constitutional Amendment 6. By depriving all accused criminal defendants held on excessive bail in Minnehaha County Jail of the rights and privileges secured by the Constitution, Amendment 6 states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of their state and district where the crime shall have been committed. Habitual criminal information holds information of prior convictions occurring out of state. To be confronted with the witnesses against him, her, to have compulsory process for obtaining witnesses in his or her favor, and to have the assistance of a lawyer for his defense, not for his prosecution. You have the right to the effective assistance of a lawyer for your defense, not for the assistance of your conviction. That part. With today's technology and infrastructure, 180 days is no longer considered a speedy trial. 90 days is considerably a speedy trial, argumentatively. 45 days, 30 days, 2 weeks is probably a speedy trial. But the lawyers ain't even competent to hold a speedy trial within 180 days, so it's not the technology and infrastructure that it is. It's the fact that they're appointing these defective lawyers, these surrogate prosecutors that have dreams and ambitions of being prosecutors and see, they don't want it to be defense lawyers. So they're false advertising. They're impersonating defense lawyers and carrying out the duties of a prosecutor. If that isn't fraud and it's off, I don't know. I'd like a second opinion, concurring or otherwise. To which the state of South Dakota is acting through several agencies, employees, Minnehaha County State's Attorney's Office, Minnehaha County Public Defender's Office, Minnehaha County Public Advocate's Office. Law enforcement officers and judges are privy to and guilty by association. They do collectively violate and deprive the rights of the people. The state of South Dakota and others have customs, policies, or practices that deprives people of several rights and privileges, if not all of them, to include customarily appointing defective counsel to assist the accused in every instance. The state has failed to rid the county's offices of such defective employees and reappoint defective counsel to other defendants, allowing defective and ineffective legal agents to abandon their duties. Is a fraudulent scheme bordering on a racketeer influence corrupt organization operating as a court of law. The defective assistants that are customarily appointed by the states render no assistance whatsoever to an accused. The court-appointed lawyers, the privately retained lawyers, customarily claim that their assistance is beyond the scope of service. It appears they are issued inadequate scopes and are in need of pay cuts and major sanctions, discipline, and re-education to bring the effective assistance within the scope of services and duties. Or just disbar them from practicing law. Make them get a real job. I encourage lawyers to declare to the state's attorneys that negotiating guilty confessions on the state's behalf is beyond their scope of duties, as it infringes on the right against self-incrimination. As defendants, court-appointed assistant lawyers are required to assist in his defense rather than assist the state obtain guilty convictions. I request the Department of Education be informed immediately, as well as the American Bar Association and any other state bars. South Dakota Codified Law 22-7-8.1, the Information Part 2 Habitual Criminal enacted by South Dakota legislatures, contrary to U.S. Constitutional Amendment 7, which reads in part, the rights of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States. To which Minnehaha County State's Attorney's Office is attempting to re-examine prior convictions, which were tried by jury. They put I went to a jury trial on the convictions they're talking about. I went to a jury trial on one case. That one case resulted in like 2 felony convictions. They separated those 2 felony convictions and counted them as 2 separate strikes. They're not allowed to do that. In their statutory law, they cannot do that. So any conviction arising on that March 6, 2006 thing that they got, that was all one case. They could only use that whole entire case as one strike. You have to have separate cases with separate convictions for it to count as an extra strike for felonies, I guess. And what they were doing was they were saying I had like all those misdemeanors count as felonies over here, and that's where the coercive tactic came in to obtain an involuntary guilty plea. And I had no way to reference or cross-check and check and verify what they were telling me. They wouldn't give me the law books. That's called double jeopardy violation. That's called malicious prosecution. They know the law. They're presumed to know the law.
Misdemeanor.
If you're misstating the law, that's misleading information. So if they mislead you into something and because of that misleading information you signed a contract, that nulls and voids it there too.
That's a misdemeanor, not a felony.
So if they've been abusing the law.
Case number here.
To a certain extent like this. I
Then
think
they
the
did it
law
again on this
is
case
not
number,
good.
and they did it again on another case number. That's double, triple jeopardy. They can only use this enhancement thing on one time, and that's it. So
They can't deny that shit. It's all on the record.
they used it here, they used it there. The same
Good
allegations.
morning, everybody. Good morning, TikTok. The right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States. And this was a writing I did in this case. This is a copy of it, but you can see the original nice and clear up here on 421 CB 04179, document 32, filed on January 18th, 2022, page 508. To which the county state's attorney's offices are attempting to re-examine prior convictions, putting in jeopardy twice for a previous conviction. To continue allowing the South Dakota state courts to re-indict, re-examine, recharge, and impose any penalty based on prior offenses violates this constitution and is a severe miscarriage of justice. Habitual offender statutes and others in that chapter should be scrubbed and deleted from the law books and all references made, as they were enacted by legislatures in violation of the Title 18 U.S. Code 241 and 242, and against the rights and privileges and immunities secured by the Constitution. Deprivation of rights. South Dakota has adopted a custom, policy, practice, or law that violates the Constitution. That being habitual offender laws are contrary to the U.S. Constitution and are not withstanding. Take judicial notice of Section 1, legislative powers, notes to decisions in general, miscellaneous. Legislature can enact substantive rules of law. United States versus Lockheed. Oil and gas, something. A party seeking to persuade the court that reconsideration is appropriate bears the burden of demonstrating one of the following: an intervening change in the controlling laws. Supreme law of the land is constitutional. Double jeopardy law is controlling law. The availability of new evidence that was not available when the court issued its order. New evidence being my statements herein, the what do you call those warrants, the order suspending the speedy trial, right? That's new evidence, right? See also Crimson versus New Jersey Department of Education. The purpose of reconsideration is to correct manifest errors of law or fact to prevent injustice. The court will grant motion for consideration only where its prior decision has overlooked a factual or legal issue that may alter disposition. Andreco versus Sunrise Senior Living Incorporated. On this one, I requested the court to grant injunctive relief, barring state from violating double jeopardy protections. 2, delete Part 2 habitual offender laws from records as it was enacted contrary to Constitution. 3, remove from office and impeach any legislator, judge, lawyer, prosecutor who willfully engaged in the unconstitutional law. Fine and imprison under Title 18 U.S. Code 241 and 242. 4, I want monetary compensation to aggrieved parties of the unconstitutional law and reduced sentences for any convicted felon on the Part 2. Order the states to expunge prior convictions from records upon completion of sentence. 7, delete and discontinue the practice of dismissals without prejudice, as a dismissal without prejudice is prejudicial in and of itself. 8, discharge from duty and disbar from practicing law, private retained or court-appointed ineffective counsel for breach of fiduciary and breach of contract obligations. State of South Dakota, by and through its several employees, have adopted a custom, policy, or practice that violates the constitutional rights to a speedy trial, in that an unknown judge has issued an unconstitutional order waiving speedy trial rights and is guilty of Title 18 U.S. Code 241. I didn't know all about that order. I knew about the order, but I didn't have a copy of it at the time I wrote this and submitted this. But I was able to obtain that document. It was very, very hard to get that. It was like pulling teeth, man, from a lion with no sedatives.
All the documents are uploaded on my profile somewhere. And you can do a court record search. This is a court case number up here that I filed it, but I keep filing it over and over in different new cases because they keep dismissing them and obstructing justice. And then rather than reopen the case under Rule 60B 2, 3, or 4, whatever it is. I tried to reopen the cases, so they kept telling me I could just file a new case. I filed a new case. So, in me filing the new case, it's, see, another case number. This one's 4076. So they keep getting me to pay these filing fees and things like that. They want to open a new case and then make me liable for a new filing fee. Here's another case. So now I'm at another new case. And I'm taking these all to the Supreme Court because it was an ongoing criminal enterprise. The obstruction is a continuing offense.
No, Alan Wolf. 3 charges out of the same night and prosecuted separately is called double jeopardy? No, they don't prosecute them separately.
It's called multiplicitous and duplicitous. So right here, this is one case number. They're charging me with an enhancement for the escape on this and a misdemeanor, which they converted into a felony because they say, well, so they deny the full faith credit of the state of Iowa, right? The full faith and credit clause. They have to honor Iowa's records that this is a misdemeanor. So my lawyer is telling me, what they did tell me at the time was, well, if you had committed it in this state of South Dakota, that's a felony here. So that gets reclassified as a felony strike for purposes of this. So if it just had just the one, it gets enhanced one point. So since it was 2, it automatically jumps up to a 25-year sentence on any felony. So this is one case number. Now here's another case number. And then there was another case number, 2161-7169, I think, or 68. I don't have that case number, but they charged me again on this case number and a separate case number on 2 ongoing cases. So they're going to use it to enhance this when this one on this case was the very last case. So they filed it on this case. They filed it on the 6928. Maybe it was 216928. And then they filed it again on this one. So that's a double jeopardy enhancement because they're giving me different case numbers with this same information. And they were going to present this to a jury, but then they call these people as witnesses. This person ain't a witness. This person ain't a witness. Mike Milstead, what did he witness? Sheriff of Union County? Yeah, you should have called him. He was a witness. All right, now, where's the Iowa witnesses? This right here is a misdemeanor, tampering with records. Possession of controls, that's a misdemeanor. This never happened, furnishing controlled substance. Failure to affix tax stamp anyways. This 3/3/2006, 3/3/2006, 3/3/2006. This is all one case. So these 3 right here is supposed to count as one. You can't separate them and say, oh, you got 5 felonies now. That's not true. That's not how that works. So that was the threats, duress, and coercion. Well, if you did all these over here in this state, these are all felonies. So now you got 5 strikes instead of just the 2 or the 1. That's threats, duress, and coercion. That's giving me false information, misleading information, and they're misstating the law under this chapter. That's an abuse of office. There's no discretion to misstate the law and misapply the law. Now, the second degree escape was a wrongful conviction. Where's the witnesses for them guys? So if you look up this law and look at the whole section, the 22-7, it will tell you in there that any felonies arising out of the same transaction of 3/3/2006, 3/3/2006, 3/3/2006, all these count as just one. But again, these are misdemeanors, so these don't even count. And not only that, I went to jury trial on this. I was not convicted of that. I was convicted of that. Failure to affix tax stamp. Then they used the escape again, which was a false charge, false imprisonment, a malicious prosecution. I don't know who they deposed. There was no record of a deposition. Prosecuting attorney. I don't even know whose signature that is. This was a misdemeanor again. So they did change it after I made some things and they put it to 1, but then again, they used the misdemeanor out of the charge to try to enhance it as a prior felony conviction, wrongful conviction. So this was not even a legitimate factor.
Executing the same. So you go to trial on one case, and the jury has to find you guilty of each of the charges. That's not double jeopardy. Now, if you go to prison and you satisfy your sentence, you complete your sentence and you get out, and the prosecutor, you get a new charge down the road of, let's say, a DUI. Third, they charge you with a felony. Now they're gonna bring up those prior convictions that you went to jury trial and got convicted on, and they're gonna say, well, you got 3 charges there, so that counts as 3 strikes. No, that's all one case, it counts as 1 strike. For the habitual offender purposes. Now you got a new DUI. DUI third, DUI fourth, whatever it is that enhances it to a felony. Now, they can only use that habitual offender one time, once they hit you with the offender. So now let's say, like I did, I bought it out. Now they're talking about, you got this case for whatever they arrested you for, and now you got this other case of second degree escape. 2 separate case numbers. They're going back and they're using the same prior convictions that you went to trial on 6 years ago. They're saying, oh, well, now you're a habitual criminal, so we're gonna charge you with the habitual information on this new case and on this other new case. They can't do that, that's double jeopardy. They can't keep charging you as a habitual criminal over and over and over. They can only use the enhancement one time. So that's, now you're looking at 25 years on this one, you're looking at another 25 over here, or now you're looking at a life penalty, lifetime penalties. Now we're talking about two consecutive life sentences or concurrent life sentences. That's up to the judge, and that's called coercion. That's under threats, duress, and coercion, and they're misstating the lawsuit. Title 18 U.S. Code 241. The meeting of the mind occurred when subordinate actors advocated and blindly followed under the judge's unconstitutional order, which was granted with the excuse of COVID-19, where subordinate actors utilized it abusively, delaying speedy trials unreasonably for any and all random excuses except COVID-19 pandemic. The Minnehaha County State's attorneys, advocates, defenders, and several private practice law firms and several judges acting in unison did knowingly and willingly deprive pre-trial detainees and unconvicted defendants of several constitutional rights prior to COVID-19, during COVID-19, and left unchecked and undisciplined would continue to do so. State Bar of South Dakota has a policy fining and suspending from practicing law its members. Why not use it? I'm all for it. Let them go pick up trash. Let them do some community service, some real community service. You know, we get kids to do all kinds of community service all over. I'll let these guys do some community service for once. Title 18 U.S. Code 241, 242 has a range of sanction ranging from 1 year to life, depending on severity and extent of violations, and it has a capital punishment in there. So this was submitted and there's evidence as well. Come down, pro se petitioner enters this writ of habeas corpus challenging the constitutionality of my pretrial detention to the judicial officer of said court. So what I did with this one, this is the copy I sent to the federal court. So when I wrote it out, I left this in pencil because I made 3 copies of this. And then I went up here and I wrote Minnehaha County State Court, Second Judicial Circuit Court. So I sent a copy of this to the federal court, the state court, and then I filled the state court, and I told the federal court that I was doing that to hold off on it so that they could take judicial notice of it and see how the state court reacted to it with this. To the judicial officer of said court, in the above style numbered cause, move this court to grant this petition, and in doing so will demonstrate the following: ineffective assistance of counsel, 23A-46-6, writ not precluded. I was currently in the custody in violation of the United States Constitution, South Dakota State Constitution, and several South Dakota state statutes codified therein, held in the custody at the Minnehaha County Jail under ID number 2369118 for the false allegation of assault on law enforcement officers Aaron Boyer and Justin Ritter. See petitioner's counterclaim in District of South Dakota Federal Court, Gomez versus Ritter et al., case number 421 CD 04179, in violation of the Fourth Amendment. I asserted my rights under the 4th, 5th, 6th, 8th, and 14th Amendments of the U.S. Constitution and South Dakota Codified Law 16-18, the powers and duties of an attorney. Rules 1.1, 1.2, 1.3, 1.4, and Rule 3.2, expedited litigation. I demanded a speedy trial pursuant to my Sixth Amendment right under the U.S. Constitution and South Dakota State Constitution, Article 6, Section 7, South Dakota Codified Law 15-6-38B, South Dakota Law 23A-44-5.1, South Dakota Speedy Trial Act, and the 180-day rule. I have exhausted state remedies on court record before Presiding Judicial Officer Robin Hallman on May 27, 2022.
Yeah, Stephanie, I was talking about the header. So I wrote this out and I made 3 copies of it. But when I made the copies, I left this United States District Court part, I left that blank. And on this copy, I put the United States District Court, and on the other copy of the same thing, I put Second Judicial Circuit Court of the Minnehaha County, so the state county court. And then I appealed it up through the state courts, as well as, and I notified the federal court that I was filing these simultaneously in the state and the federal court to try to put a stay on this federal proceeding. And then what they did was they dismissed it for failing to exhaust the state remedies that was in the process of being exhausted. So I just wanted them to know that that was going on in the state court. So they weren't exercising their supervision powers.
Between 3 and 4 p.m. This petition is properly before this court pursuant to 28 U.S.C. 2243. This court must order my release. South Dakota Codified Law 23A-44-5.1. If defendant is not brought to trial before the running of time for trial, prejudice to the defendant is presumed, and the defendant shall be entitled to a dismissal with prejudice. South Dakota Constitution, Article 6, Section 1, 4, and 5. South Dakota Constitution, Article 6, Section 7. In all criminal prosecutions, the accused shall have the right to a speedy public trial reaffirmed in Title 18, Section 3161. SDCL 23A-44-5.1. South Dakota's 180-day rule. Thus, the South Dakota Supreme Court is in violation of its oath to uphold the U.S. Constitution and the South Dakota State Constitution, invoking the protections against unconstitutional state provisions in SDCL 1-1A-1 through 1-1A-4. This court, pursuant to SDCL 15-6-40A, issued a scheduling order with deadlines, to which this court, its officers, and appointed counsel are in contempt of in that they did not adhere to it. Also SDCL 15-6-40C. In the absence of the adverse party, a court may proceed with the party's case and take a dismissal of the complaint. Under SDCL 22-30A-A. So if they're charging you with something, you got a court date, and the accuser doesn't show up, the police officers never showed up, they never showed up to court, they were absent. They didn't come back to respond to any of my motions to dismiss. The adverse party was not present at any of these proceedings, at any of these court cases. So the state court erred in not dismissing it. Under South Dakota Codified Law 22-30A-16-2, I had an honest and reasonable claim of right to property as an affirmative defense. I was unreasonably seized, contrary to the Fourth Amendment, deprived of liberty and property without due process of law. A statement of facts. On October 1st, 2021, domestic terrorist officers of the Sioux Falls Police Department responded to a call for a standby police presence for myself to retrieve my personal belongings from my residence, where I had a right to be under a contract for deed, entered into with the seller and Wade Randall. See case number 421 CD 04179, document 1-1, filed 11/3/2021, page 10 of 68, page ID number 21. Contempt of court, no contact order. Worth noting, the no contact order was for a specific person. Officer Ritter and Bobier arrived, and Daniel has a right to be free from excessive force, police brutality. Said officers did trespass upon Daniel Gomez's dwelling. See South Dakota Codified Law 22
No address. No address.
They did assault with dangerous weapons, giving rise to my right to defend my life under South Dakota Constitution, Article 6, Section 1, and under SDC.
There's no address. I was not barred from going to any property.
South Dakota Law 22-18-4.1, Sections 1 and 2. I was on my property for the lawful purpose of retrieving my work tools, ID, and other necessities, including my evidence. Officers' conduct and actions were disproportionate and inconsistent with their training and did put myself in fear of imminent death under SDCL 22-18-4.3. Under South Dakota Codified Law 22-18-4.6, my use of force was reasonable when necessary to prevent or terminate another's trespass or interference with my possessing my real property. Wherefore, the weight of the state's evidence against me in this regard is outweighed by my evidence showing that officers provoked the use of force against themselves when they feloniously assaulted me, thus falling under South Dakota Codified Law 22-18-4.9, Section 2. Furthermore, in the case of State versus Means, March 14, 1979, South Dakota Codified Law 23-34-2 states, if a criminal action, unless postponed by defendant's application, is not brought to trial, the court must order the prosecution dismissed. I cited the following case law in supporting arguments. 1, 2011 U.S. District Lexus, Reynolds versus Graham, August 11, 2011. If a police officer intentionally or recklessly provokes a violent confrontation, they're liable to get injured and liable for damages. Here in this case, officers intentionally committed a kidnapping under color of law and felony assault in violation of Title 18 U.S. Code, Section 113. Why is there a blank page? Shit, there's some extra pages in there. Alright. This was all handwritten shit. The courts accept handwritten shit. This shit don't have to be certain font size, don't have to be nothing. You can handwrite these things up, man. Don't let them clerks fool you. This was filed with no problem. This was filed with no problem. 2021, South Dakota 57, People ex relinquish, N.A. That was a case of a minor. There can be no doubt that officers are permitted to use force when their safety is threatened. Absent a threat to their safety, they're not supposed to use force. Here, Petitioner Gomez, I did nothing to threaten officer safety that could reasonably justify the use of force employed by Justin Ritter and Aaron Bobier. My peaceful disobedience to officers does not, as a matter of law, give right to officers to beat me, to defend themselves. See case State versus Bogenreef. United States ex relinquish Means versus Solon. A policeman's use of force becomes unlawful when it reasonably appeared as an attack squad. As it reasonably appeared and felt to me as an attempted unaliving on October 1st, 2021 at my residency. Means versus Solon. South Dakota law makes no distinction among those allowed to defend themselves and coming to the defense of another. Now South Dakota State attempts to overrule and adopt a law that one cannot defend himself against police brutality and that I must allow officers to beat me until they tire themselves out. I don't consent to that. I don't consent to that. Supreme Court of South Dakota and State versus Lucky. The Supreme Court of South Dakota has accepted the objective reasonable person standard. You can't, it's prejudicial to say the objective officer on scene, the reasonable officer on scene. It creates a prejudice in the minds of a potential jury pool. The objective reasonable person standard. So that right there removes the insinuation that the only reasonable person on scene is that of an officer. So if they say the reasonable officer on scene in a jury instruction, it's a prejudicial jury instruction because it plants this seed of thought in this jury that, oh, well, who's the reasonable officer? And then they're just focusing on all those officers that come up and testify. If they limit that jury instruction is a good instruction, but if they limit it to a reasonable person, so that can include anybody that is or is not an officer. What was the objective reasonableness of the people on scene? My objective was to obtain my court documents and evidence that I had here. This stuff here, I was trying to get this stuff and my belongings. So that was my objective. What was his objective? His objective was not reasonable because it was to obstruct me from getting this evidence out of the house on an ongoing case I had. To deprive me of my property. That was his objective. So here my reasonable objective was to retrieve my property that I am lawfully and rightfully entitled to. You can see the original document. There's some stuff in here the permit didn't pick up, some writing here. It's on the original document. SDCL 23A-3-5 provides in part that no person shall subject an arrested person to more physical restraint than is reasonably necessary to effect a lawful arrest, a reasonable seizure. Use of excessive force is impermissible even when during a lawful arrest. Here, I did not provoke an assault, nor did I instigate violence, nor provoke a conflict. Supreme Court, South Dakota, 1952, State versus Meyer. It is lawful for a person who is being assaulted to stand his ground and defend himself. That's all I did. I was being assaulted and I lawfully defended myself. 38 South Dakota 159, State versus Bell. When a man is assaulted on his own premises, he may arm himself if he can, and standing upon his own doorstep, he may defend himself against all assailants. There's no distinction based on employment as a police officer. If an officer acting under color of law commits a forcible felony, then as a citizen or man, one is justified in defending against such attack. Home security video footage will show an aggravated felony assault by individuals attacking myself on the porch. That video is posted. I posted it several times. A couple people complained they got it taken down for showing violence, but it's still up there. So within the first 6 videos I ever posted. Supreme Court of South Dakota, State versus Spadhurst. I wish to point out that this assault arrest was reckless. This Native American was assaulted and arrested on private property, his own. I would point out the same reckless actions of police officers in my case. State versus Lethman. After careful examination of all the evidence in the case, we are clearly of the opinion that the defendant was fully justified in this case in believing that officers either intended to unalive him at the time or was making a felony assault upon him calculated to do great injury. Means versus Sullivan again. Alterations from the original. However, the officers were not authorized to use unlawful force in a standby assist call. In assisting a protected party, give myself the clothes where I awaited officers' arrival. I remained seated on my porch. If the police were the aggressors in assaulting myself, it was unlawful and certainly uninvited by peaceful disobedience, peaceful protest, and peaceful demonstration against an unreasonable seizure of my property in person absent due process of law, violating the 4th Amendment of the U.S. Constitution. Therefore, the fact that I peacefully and lawfully remained seated on my porch, on my home where I have a right to be, in non-compliance with an officer's order, could not justify the officer's aggravating felony assault in the misuse of PD-issued self-defensive controlled electronic weapons in an offensive criminal manner, manifesting an extreme indifference to the value of human life that cannot be viewed as acts committed in the performance of their official duties. Those officers were responding to a call for me to retrieve my clothing and my property. See State versus Mobile. Citations in 77 ALR 3D 281 through 300. The right to resist excessive force used in accomplishing arrest. See the Castle Doctrine. South Dakota Stands Your Ground Laws. Title 18 U.S. Code 241-242. Deprivation of rights and conspiracy against rights. Part 5. Speedy jury trial violations. 6th and 14th Amendment. The 6th Amendment to the U.S. guarantees an accused a speedy trial. You got Cooper versus North Carolina. Here Gomez has made repeated demands for speedy trial to Caleb Paulson, Manny DeCastro, the jail administration, court administration, to which, upon defendants' demand, the state, the courts, and defense counsel have a constitutional duty to make a diligent, good faith effort to bring you before the circuit court for trial. Smith versus Hui. See attached exhibits of grievances pertaining to speedy trial demands. My mother has passed away due to cancer. She intended to testify on my behalf. The appointed assistant, Caleb Paulson, was notified of the fact that my mother, who is now deceased, wanted to testify via Zoom, prejudicing my defense, and that a cooperating witness is no longer available to testify. Due process has been violated, and that no meaningful due process has been accorded to Daniel, in that no deposition hearings, no pretrial motion hearings, no evidentiary hearings, no immunity hearings, no preliminary hearings, no due process whatsoever have been afforded to me. The only motions ruled favorably were for the sole benefit of the defense counsel's wish to delay my right to a jury trial with false and misleading statements. The state has no probable cause to prosecute Daniel for assaulting law enforcement officers, and those charges should be resolved by the court in favor of my writ. I demanded speedy trial, and I have not consented to waive that right pursuant to SDCL 15-6-38. B. Demand for speedy jury trial. Defendant was arrested on October 1st, beaten, assaulted, and advised by the courts of my right to a speedy jury trial and acknowledged understanding to which the courts pursuant to SDCL 15-6-48 issued a scheduling order with deadlines to which the state courts and defense counsel in contempt failed to adhere to, violating constitutional speedy trial and due process rights. SDCL 23A-44-5.1, the time allowed for disposition of criminal case. Section 4B, requires consent from the defendant, to which defendant had not granted consent to delay. Counsel failed to prepare. If the defendant is not brought to trial before the length of time for trial, prejudice to the defendant is presumed, and the defendant shall be entitled to dismissal with prejudice. Reaffirmed by Title 18, Section 3161F. Time limit between arraignment and trial shall be 180 days. See scheduling order dated 10/19/2021, Exhibit 1, and motion order for delay filed 1/3/2022, Exhibit 2. Motion for delay filed 3-2/2022, Exhibit 3. Motion for delay filed on 4/27/2022. All motions were considered and granted without my consent or without my knowledge, and trials were reset in every instance 1 week prior to scheduled trial, several days after the trial reset deadline. I move to exercise court's power to dismiss with prejudice CRI 21-6928 and CRI 21-7147 due to the state's, the courts, and lawyers' constitutional violations. Pursuant to Chapter 16-18 Rules of Professional Conduct, the duties of the lawyer and special responsibilities of prosecutors. Any waiver of rights must be obtained in writing. Lawyers were not authorized ever to waive any speedy trial rights, nor did they obtain a written waiver or verbal. Any and all delays were considered and granted without my consent and with deliberate indifference to constitutional rights, prejudicial to myself. Pertaining to the delay filed on 4/27/2022, DeCastro deceives the court by signing electronically a statement. He falsely represents to the court that he had spoken with me about that particular motion and had obtained my consent. DeCastro deceived the court, and Daniel Gomez had no communication with DeCastro in regards to delaying trial while I was out on a furlough for either my mother's passing or the funeral. I got 2 little furloughs. Anyways, and they said I was a flight risk and this and that, but I came back from the furlough twice to the county jail. I returned to custody to face these charges and defend myself, right? And they just delayed trial for 11 more months after I came back. Anyways, any and all communications prior to furlough are on the jail email servers for inmates. No such discussion or notice was given to me. See grievance exhibit number 2, attachment 1 of 1, and corresponding motion in order for delay. In closing, pro se petitioner asserts and alleges supported by legitimate internally generated documentation in the exhibits herein and the U.S. Constitution, State of South Dakota State Constitution, and reaffirmed by federal and state laws, my federal constitutional rights, due process rights, speedy trial rights, 180-day rule have been violated. These cases here, 1, 2, and 3, are speedy trial cases. Service. Send all this to the Supreme Court. Again, you can handwrite this stuff from county jail. I do all this from county jail. These ones that are handwritten like this. So with all these petitions, you see the federal courts denying me my right to a 7th Amendment civil jury trial. Oh, it's dismissed on this summary judgment. Summary judgment is an unconstitutional policy adopted by the United States courts. Summary judgment does not grant you, it violates the 7th Amendment principles of your right to a civil jury trial. Summary judgment, the failure to state a claim, and all the other reasons that they dismiss your case without even serving the other party. Those practices and policies are the rules that are violating people's constitutional right. They contribute to the violations. by denying you the relief. It also violates your First Amendment right to petition. They're gonna say, oh, well, you got your right to petition, nobody stopped you from making the petition. No, but you stopped the petition from going forward and getting a Seventh Amendment jury trial. You're doing, who agreed to have a bench trial? And now these judges are practicing law from the bench, defending people that haven't even been served with these complaints. They're not even allowing them to see the complaint. They're shielding them, they're obstructing, what do they call it? It's called harboring. They're harboring these people from justice. Well, let's go to the habeas corpus petition. Let's skip this one, we'll go back in time. Since they brought up my second degree escape charge and habitual offender statute on 2 cases. This is my appendix E that went to the Supreme Court here in the United States. Exhibits of fabricated warrants, docket history. Here's the fabricated warrant. So my lawyer told me that there was a warrant for failure to appear. The police. Police officer told me there was a warrant for failure to appear. See Melissa Larson, she's a clerk of court. She signed it there as a magistrate judge. Right here. This is the circuit court header. This is a list of the judges. 1, 2, 3. This is the list of magistrate judges. There's only 2 magistrate judges. This document was filed September 16, 2009, after that. So, Melissa Larson was still employed there. She was not a magistrate judge. She impersonated a judicial officer. See, this is her true position up here. A clerk of court. Melissa Larson. See the signature? Same signature. This Exhibit C portion was stamped and filed on March 1st, 2010 when I did the habeas corpus. They dropped the charges for the unlawful arrest and created a whole different charge.